Next is, if I'm just offering my house to Vinith, and I'm just demanding that you should not carry out any sort of trade profession. So I'm restraining his lawful business or trade or profession. If there is an agreement, setting agreement is void in nature. So agreement in restraint of marriage, agreement restraining the right of marriage, agreement that is restraining your right to carry out any profession, trade. Oh, it's a fundamental right in itself, is it? Article 19, Clause 1, Clause G states you have the freedom to practice, or you have the freedom to carry out any trade, occupation, or profession of your own choice. It's a fundamental right in itself. You cannot restrain the right of lawful profession, trade, and business. Not regarding unlawful. So it should be lawful. So should not restrict any person for carrying out a lawful profession or business or trade. So that is, and another instances. If suppose I and Meera have entered into a contract, and my demand or the terms of the agreement is that Meera should not file any case to enforce this contract. So I am restraining the legal proceedings. I am restraining the right to legal proceedings, right to enforce a contract. So such restriction is void. Such agreement which restraining the right to legal proceedings is void. So these are the instances by which the agreements becomes void. So agreement restraining the right to marriage, agreement restraining the right to carry out lawful profession, trade, or business. And agreement which restraining your right to legal proceedings or legal formalities for what? For enforcing the contract. But there are some instances where you can say that, suppose, for example, in legal proceedings, first of all, if there is a dispute, you can just refer the matter to the arbitration. And the amount or the award can be recoverable. So such conditions can be. That is, you have the right to legal proceedings. So first of all, you can refer the dispute to an arbitration. That can be. But completely restraining a person for legal proceedings, so that particular agreement is void. And again, I've said that suppose a person is restricting his lawful trade, profession, all. So that particular agreement is void. But there's an instance where you can say that when there is a sale of our goodwill, so at that you can restrict that you should not carry out the very same business within a particular local area for a particular period of time. That can be restricted. So there was the case of partnership, or if there is at the time of dissolution of firm, or there may be instance when a particular partner ceases to be a partner. So at that instance, you can say that you cannot carry out the very same business within a particular local area within a particular period of time. So such restrictions can be made. When there is a total restraint to the trade or total restraint to the legal proceedings, such agreements are void. And next is there is an instance of agreement again void due to uncertainty that we have already discussed earlier. Suppose I am selling my horse. I am having a white horse and a black horse. But I am just not mentioning which horse I am selling. I am offering my horse to Meera. So there is an uncertainty. Such agreements are void. And then I have already discussed that someone is offering 100 tons of oil. But that person is actually having the business of mustard oil or coconut oil or olive oil, sunflower oil, all kinds of oil. But he is not mentioning what oil actually he is offering. So there is an uncertainty. Such agreements are. So agreements in restraint of marriage or trade or legal proceeding, and also uncertain agreements, such agreements are void. Another important section is section 30, that is wagering agreement. As we all know, Suppose a cricket match is going on. There will be a bet which team is going to win. And if that particular team wins, we'll give this amount. And I'll have to get this amount. So these are all bets. So wagering agreement is based upon an uncertain event. It may happen or may not happen. But that agreement in the form of wager, that is void. Suppose I have made a bet regarding the match, and the particular team which I have just made the bet has won, and I should get the amount. But the person is not giving the amount to whom I have made a bet. Whether I can approach the court for the enforcement of that particular agreement? No. Because wagering agreements are void in nature. I have no right to enforce such an agreement. It is wagering agreement. Then section 31 to 36 is dealing with contingent contract. It is based upon some contingency, either happening or non-happening of an uncertain future event. So it is actually a contingent contract based upon some contingency that may happen or may not happen on the basis of a future uncertain event. So if a particular instance is happening, then I can enforce it. If my agreement is, if a particular instance does not happen, then what happens? You can enforce it. So either to do or not to do a particular act. It is based upon some contingency on the happening or non-happening of a future uncertain event. That is contingent contract. Simple examples I could just mention. If a person asks another person that, or he's offering a 50 lakh worth house to another. If, suppose Sharath, if Sharath marries one Reena, so a person offering a 50 lakh worth house to Sharath if Sharath marries Reena. If he marries Reena, of course he will get that. On the happening of a future uncertain event, if that particular uncertain event had happened, he is entitled to recover them. He is entitled for that. That is the example. Another example is if Meera says to Sharath that if that particular ship, if a particular ship does not return, I will give my 20 lakh worth property. That particular ship has sunk, so it will not return. So on that non-happening of that particular event, if that ship does not return, I'll give my 20 lakh worth property. So it has sunk and it is not going to return. So this person, Sharath, is entitled for that 20 lakh rupees property. The property worth 20 lakh rupees, who is entitled for that Sharath? So that is contingent contract. Either happening of an event, which is future uncertain event, and if it happens, this person is entitled. Someone says that non-happening of the particular event, if that particular event does not happen, this person is entitled. But suppose if it is for a thing that is impossible to happen, someone says that get some gold from sun, or let 2 lions enclose his space. That's not going to happen. So such impossible thing or impossible matters are there. Then that particular agreement is void. But contingent contract, if a particular event happens, it's a future uncertain event, that event becomes certain or it happens, that is valid, that is enforceable. For some says not to happen. If that particular event does not happen, then this person is entitled for that amount. It's enforceable. But if the subject matter itself is something which is impossible to happen, then you can say that that agreement itself is void in nature. So that is stated as section 31 to 36. So the next portion is actually discharge of contract, a very small portion. So we'll discuss in the next session. So thank you all.